Hi, good afternoon. My name is Amanda Smith. I am a senior associate here at Tully Rinckey. I, on a regular basis, do handle MSPB appeals, as well as petitions for review from initial decisions from a judge, and have also handled appeals to the Federal Circuit Court of Appeals regarding any MSPB matter. So I understand the other month, there was a webinar that was covered by my colleague, Mr. Grogan, that handled disciplinary actions and responses and your rights and what to know when it comes time to respond to anything that may be proposed by your employing agency. Today, we're going to kind of pick up, I guess, where he left off, and to handle what is the Merit Systems Protection Board. The MSPB is what we'll refer to it, just to kind of save the tongue twister, and to make it a little bit clearer when I'm talking about all of these things today. And then we'll go into the jurisdiction. What kinds of cases can the MSPB hear? Where can you appeal to the MSPB from? It's not just simply maybe actions by your agency, but other federal agencies as well. And then the appeals process, like I mentioned, a petition for review, you're challenging, you're filing an appeal in federal circuit court, those types of things as well. We'll briefly touch on and so you understand, that this isn't the end. If you get a decision that's unfavorable from an MSPB judge. I'll also show what the initial appeal form looks like and the different stages for you to have familiarity with at the MSPB, and know what's coming or what rights you would have as the appeal is processed with a judge. And then finally, we'll just touch on the benefits that you may get from having an attorney at various points throughout this appeal process. So if we can go to the next slide. Okay. So the MSPB is a separate, independent, small federal agency. It is an administrative court, so it's not where you're going to, maybe like you think of a Law and Order scenario or courtroom. A lot of the cases that the MSPB handles, they do virtual now. They did so before COVID, but I don't see them really going back to in-person matters if they don't have to. There are a lot of teleconferences. They have their own platforms for Zoom. They're pretty streamlined now, but it is an administrative court. It is not a federal court. It's not a state court, those types of things that you might think of. Now, the MSPB is a small federal agency. It is made up of judges. They do have attorneys. There are certain other employees for the MSPB, but mainly their purpose is to protect the federal employee from agency overreach or agencies taking action that they either don't have supportive evidence for, that they shouldn't have, that's in violation of either a federal merit principle or other policy regulation that's been issued. A lot of the times this is making sure that you as a federal employee has been given due process, and you're not just being given a disciplinary action, or you're being removed from your position, reassigned, those types of things without some actual supportive justification from the agency. Now, the board, the MSPB, does have original, and it also has appellate jurisdiction. Now, original jurisdiction is where the board you can appeal an action directly to it. You don't have to go to some other court. You don't have to go to and appeal it within the agency. Certain things you can go right to the MSPB to appeal and challenge. Among those types of things are if you file a special Office of Special Counsel complaint, a whistleblower complaint. Say OSC, Office of Special Counsel, reviews your complaint. They issue a determination that They're not going to investigate it further. They don't see any retaliation or any protected disclosure. If they close your complaint, you do have the right to appeal that decision directly to the MSPB, and you can challenge that. Other types of actions for senior executive service employees, if you are alleged, if you're an SES and you're alleged to have performance issues, anything of that nature, you can appeal any decision by an agency after a hearing to the MSPB as well. Other types of things are, you can, and I believe the final point here on this specific slide is about appeals of a judge's decision. So if you get to the MSPB and you don't agree with, or the judge does not issue a decision in your favor, say he finds in favor of the agency or she finds in favor of the agency, the MSPB also has a 3-panel board that will review any petitions for review or petitions for an appeal, which is basically you saying, hey, I think this judge got it wrong. It's a request to that 3-panel board to review the record, to review your appeal, the judge's decision, and to hopefully reverse it and send it back to the judge for further litigation. So the next slide here, when it comes to other types though of original jurisdiction, you're talking about possible actions. We'll just kind of get basically an overview here. Actions taken by your agency. So if you are an employee and you are issued a suspension that is longer than 14 days, if you are given notice that you are being involuntarily reassigned to a new position, if you get a reduction in force, say they tell you your position is being, your position is going to no longer exist, so they're putting you somewhere else, or they're even removing you, whatever the nature is of that reduction in force notice, you can appeal that as well directly to the MSPB. Other such things are if you're reduced in grade, if you are reduced or removed from your supervisory position, other things of that nature, anything in a nutshell that could really affect your pay or your right to employment. I will note things like a letter of reprimand, a counseling, a written verbal counseling, those do not have the right to appeal that to the MSPB. So a rule of thumb would be if you get a 15-day suspension or something worse than that, a longer term, a removal action, anything like that you're talking about, you could appeal that right to the MSPB. Other types of appeals could be something along the lines of if you applied for a position and you were notified that you were not suitable or that you were disqualified for it for some reason, those you can also appeal to the MSPB. If you are terminated for performance, conduct, any reason that they give you, and you are a full-time competitive employee, you do have MSPB appeal rights. Now, when I'm saying your ability to appeal these actions to the MSPB, it's obviously following your written or oral response to these actions. But it is not where you are alleging necessarily, or you have to allege that there's some nefarious reason for what the agency is doing. It can be as simple as the agency has not shown you the evidence that they have, or whatever it is that you raised in the response period. It can include that you believe it's retaliation or discrimination. It can be that that you have issues with your supervisor. They create a hostile environment. You can include those as affirmative. They call them affirmative defenses. But my point that I want to be clear here on is that you don't need anything other than the agency does not have the support for taking this action. They haven't proven that a removal, a suspension, a reduction in force. They haven't proven their case. They haven't shown that that's something that needed to be done. So you don't, unlike, if you hear about discrimination or other types of causes of action, you need that connection. There's some nefarious, horrible reason why the agency is doing this. You don't need that in cases of MSPB appeals. The one thing I'm going to note as far as a probationary period, if you are removed and you are on probation, whether that's a year or 2 years, there are limited instances where you have jurisdiction at the MSPB. These are where you're claiming that there's a partisan political reason for the action being taken. A violation of a Hatch Act is kind of similar to this, where say your supervisor is giving you a removal because you are a Democrat and he's a Republican, or vice versa, or they don't agree with your beliefs on how the government is supposed to function, or they don't believe in what you believe in terms of some other divisive argument that's political in nature, not having anything to do whatsoever with your job. The other time that you may have jurisdiction to the MSPB if you're in a probationary period is if you believe that the supervisor or the agency management official responsible is discriminating against you because of your marital status. This could be because you're single, because you're married. It could be because of if you have a family, if you are you have young children. Those types of things go towards any type of discrimination that you could allege based on marital status. So the next slide we have here is continuation of jurisdiction. I think there's just a couple other points here that I want to get to before I talk about the process. In general, you also have the ability to appeal to the MSPB for anything to do with Office of Personnel Management decisions. So if you have applied for retirement, early retirement, deferred retirement, disability retirement, anything of that nature, the Office of Personnel Management is responsible for those decisions. So if you get a decision back from OPM and they say, no, you're not eligible for retirement yet, or these are your calculations based on your years of service and your high 3 salary, and you don't agree with that, say OPM put 30,000 instead of 60,000 like they should, or they just did something completely wrong, the calculations look off, you can request that OPM review calculations. You can request that they redetermine your eligibility for retirement, whatever type of retirement you're applying for. And once you go through the administrative appeals to OPM directly, and you get a decision, eventually, once you get a final decision from OPM, you will be able to appeal any OPM decision to the MSPB. The MSPB has sole authority to hear OPM decisions in regards to federal employees. So if you at any point reach a certain level of finality with OPM in regards to calculations, whether or not you're eligible for health care following a retirement, if they have denied you some sort of retirement, all of those types of actions are also directly appealable to the MSPB. The other two, which may or may not apply to everyone here, are if you are alleging violations of Ucera, so the Uniform Services Employment Reemployment Act. If you believe that your agency did something to either they removed you because they became aware of your active duty or veteran status, if you were called to active duty when you were working for the agency, and when you came back, they put you in a different position. They denied you certain types of leave. They removed you when you were on active duty. Anything like that could be a possible violation of Ucera. And that no matter what it is that the agency did, if you're alleging discrimination or retaliation for invoking your rights under Ucera, you can appeal that directly to the MSPB as well. Another act to also be aware of is VEOA, the Veterans Employment Opportunities Act. That concerns your ability to be eligible for certain positions in regards to determinations of veterans' preference. So if you have an inkling that the agency, when you applied to a position and say you were eligible for veterans' preference, either they did not apply it or they did some other, violation of where they didn't actually go through the process, they skipped over you, something occurred there, you can file an appeal with the MSPB under VEOA. Let me see here. So we went through a lot of these here. I believe in the slides, there's a lot of, it's very wordy, but it kind of gives, if you're looking to see if you fall into a specific, whether or not you're a senior executive service, whether or not you have Ucera, you have VOA, other things of that nature. It does a very good descriptive outline of when you would have jurisdiction. So other than jurisdiction, when you're ready to file an MSPB appeal, you do have 30 days from whatever the date of the action is. So if you were removed effective January 1st, you would have 30 days from January 1st to file an appeal. If you received your decision of removal on December 31st, the lawyer in me is going to want to recommend that you file an appeal within 30 days of December 31st, even if the agency is saying we're going to remove you as of January 1st. You don't want to cause more issues for yourself than is necessary. You also don't want to necessarily go by the date of when you get the decision. Sometimes agencies date decisions for certain types of actions 2 or 3 days before the effective date. The rule and the law is that you are considered to be timely filed for an MSPB appeal within 30 days of the effective date. However, I do know agencies, the cynical part of me is going to recommend for you to be safe, to not give them something to argue. Just file it within 30 days of whatever the date that they're handing you that decision is. You can find the form for an MSPB appeal online. It's at mspb.gov. This is, you can either fill out the form and fax it, mail it, or email it to the specific MSPB district office. You can also simply fill out the form online. It's an online questionnaire. It is called E-Appeal. That is where you are just filling out your name, your contact, who the appeal is against, the contact for the agency, and go through here that we have what the form looks like. So this is the form, but if you are filling out the form online, it's just going to have each box, 1, 2, 3 is going to be a question you answer online and then click next. So it's going to have your name, your contact, who the agency is, what type of employment were you when the action was taken? Are you permanent, seasonal, temporary? Were you applying for a job? Those things. You would identify what type of appointment you were. Was it competitive? Were you SES? Were you exempt? What was your position, your title, your GS level? What was your duty location? Are you eligible for veterans preference will be a question. They will ask for your length of service. Were you an employee for 5 months? Do you have no length of service because you were just applying for a job? Do you have 25 years? if you are appealing a retirement issue or things of that nature, you may not actually be, you may not actually be a permanent, a temporary, an applicant. These types of questions may not necessarily apply to you because you're retired. It doesn't matter. So, you can complete it as of, what it looked like when the date of your retirement, but some of these questions you may be able to skip. The one question that I'm going to recommend that you do not skip at any point is question, I believe it's 11. Question 11 asks whether or not you want a hearing. Regardless of if you ultimately end up wanting to do a hearing, you can withdraw that request to have a hearing at any point throughout the entire process. The reason why you would want to note and say yes now is so that you could withdraw it. If you say no now, you're not going to be able to change your mind later on. This is your initial election for what you want to do with your case. So once you get past the initial information about yourself and who you're challenging the decision of, then you get into more of the specific questions, kind of detailing your appeal in a little bit more detail. So you would have part 2 is about what, if it's an agency decision or an agency action, what is the action that you're challenging? Is it a resignation, a retirement? You've been removed, it's a suspension, a reduction in force. If none of the boxes that they provide for you fit into what you are appealing, there is that other box. You would check that and describe your decision or what the agency did as best as you can. You do have to identify the date you received the decision and the date that the decision was effective. So that comes back to, if you received the decision on December 31st, you would answer number 13 with that. And then if there was an effective date, meaning it's a date other than when you received that decision, you would also identify that. So January 1st, for instance. If you, let me see here. The next few boxes are going to be describing the agency's actions. So the print is a bit fine, but to just generally what to expect there following the initial information. If you don't have enough room on the form here that they give you, you can attach documents. You can attach a statement, a letter to your appeal. You can upload it if you're filing right online. But essentially, you're going to want to put enough information there that it's readily identifiable what you're alleging the agency did wrong. So if you're challenging a removal, it's not looking for 5 or 6 pages here. They're just looking for, maybe a paragraph or two describing, that did the agency not have enough information to make a decision? Did they not provide you an evidence file? Did they not consider your response? Did they take other actions differently with different employees? Are you raising, that this is discrimination or retaliation? Things like that, you're going to want to make sure that you do include in this initial appeal so that there's no question as to what you are alleging, and that the agency is on notice, the judge is on notice, what your appeal is going to be about. So following describing your appeal, you're going to get into other information, like such as, did you file a grievance? If you didn't file a grievance, you're just check marking a box saying no. The thing to note with the MSPB is if you did file a grievance, if you filed an EEO complaint or discrimination complaint, if you took certain types of other actions to challenge the decision by the agency, you could run into an issue where you do not have jurisdiction at the MSPB because you elected to have your case reviewed by another forum. In those instances where you're filing a grievance, you're filing a discrimination complaint, if you filed those first, then the MSPB isn't going to be able to review your case, and they could say you have to continue with the the form or the complaint that you filed in the first place. So that's what some of the information that they're looking for after that is going to be. Now, there are different sections that you don't have to complete depending on what type of appeal you are filing. And the form is going to include every single question because it's in writing. It's something that you're sending in. When you are on the website and in e-appeal, if you click no to certain types of questions, or you identify that this is challenging an OPM retirement decision or an agency personnel action, then certain questions aren't going to pop up for you. But just to kind of let you know, there's going to be questions in general. They're going to be asking you if you are filing an appeal from an Office of Special Counsel complaint. What was the date that you received the complaint decision? Was it March 31st? You identify that, you include that as part of your appeal. If you're challenging a Ucera discrimination or retaliation action, if you're alleging something under VEOA, you would also identify that. They would ask you questions. When did the last action happen? What happened? They'll ask you to describe it in a little bit more detail. For a Ucera action, you do have the ability to file instead a complaint with the Department of Labor. So a question that you may be asked is whether or not you filed a Department of Labor complaint. If you did that before you filed an MSPB appeal, they will do the same thing as if you filed an EEO complaint or a grievance for an agency action. They are going to basically say that they can't hear your case yet. They have to wait for a Department of Labor decision, and then you can appeal from that in order for the MSPB to hear your case. So just make sure when you're making decision on what forum or what court or which process for an appeal you want to do before you file anything. The other questions would be concerning your retirement decisions, recalculations, if they denied you retirement, if they say they denied you a refund of any deposits, those types of things. There's going to be a box where you can describe that as well. The last few things are just going to be simple. Do you have a representative? If you have a representative, you'd fill out a specific form for that, sign it, and send that to the MSPB afterwards. And then you'd be asked to certify your appeal. All of the statements that are made, the documents that you're uploading, you as the appellant, the person filing the appeal, is going to be asked to certify that everything is true and correct to your knowledge. Now, after you file that appeal, after you send in that initial form, within 15 days, you will get an acknowledgement order from the MSPB. An acknowledgement order is going to be telling you, hey, we received it, we're processing it, this is your judge who's assigned, and they'll give you certain deadlines as part of that acknowledgement order. MSPB appeals move pretty fast. Generally speaking, unless there's some sort of dismissal without prejudice or there is a 30-day suspension, you're talking about from the time that you start your appeal when you file it to when you may be having a hearing is about 120 days. So 4 months. It's pretty fast. They don't like to drag it out. That is through regulations. MSPB, unless they do issue orders for case suspension or dismiss a case without prejudice for longer periods of time, then you're looking at they're wanting to turn these out. They don't linger like other types of cases may. So after you get that acknowledgement order, there should be that you have to initiate discovery within 30 days. So if you get an acknowledgement order on January 1st, you have to send to the opposite side, whoever the agency representative is, and they will notice their representation as part of the case as well. You send them directly any requests for information, any requests for documents that you think you need as part of your case to win it, to prove your point, to disprove what the agency's saying. So you would have 30 days to initiate that. And then you'd have, if the agency sends you requests or for you to track, the agency would have to respond to you within 20 days of whenever you receive those requests. So just it's a different timeline. So just make sure you're tracking the 20 days. But this is in an acknowledgement order that you will receive. So it should be in writing for you to be able to track any deadlines that you have. You also will get notice that the agency, other than responding to your discovery, will be ordered by the judge to possibly provide an agency file. This is basically a response from the agency to your appeal, and it's the agency justifying the action they took, what support they have for it, and producing anything that the agency has on hand that's relevant to your appeal or your accusations that the agency did wrong. This would be you would get this before you would have to make additional requests to the agency in discovery for more information, for more documents. So if they produce something that you haven't seen before, you can ask for more information about it, things of that nature. If the agency is going to be late, they will have to ask you whether or not you agree to an extension of their deadlines, things of that nature. So they can't just make a motion to extend deadlines, or they can't just ask the judge without you being aware. The agency has to, anytime they call the judge, they have to have you on the line, and then vice versa. So you cannot contact the judge without the other side, the opposing side, present, unless there is some sort of waiver of those types of communications where you're saying, if maybe in settlement, you're able to talk to the judge without the agency because the judge is trying to mediate your case. But under any other normal circumstance and without you specifically waiving that right, the agency cannot contact the judge without you present, and you cannot contact the judge without the agency present. Now, if the agency fails to produce this agency file on time, or they fail to respond to your discovery requests, you are able to file what's called a motion to compel. You do have the responsibility to follow up with the agency, like, hey, I sent you these requests. You were supposed to turn them over to me on March 1st. You did not do so. I have 10 days to contact the judge, and I will do so if you don't, tell me what's going on or provide the responses by then. If March 10th rolls around, there's no response from the agency, then you can file a motion to compel with the judge. In that, you're outlining, this is when I served the requests, this is when the agency was supposed to respond. All of these requests are relevant to my appeal and is information that I don't have in my possession. And you're saying, this is what the agency produced, if they produced anything, or this is they're refusing to produce something. So then that gets filed with the judge. The agency will have a chance to respond, and then the judge will make a decision. Depending on the judge, they may call a conference, want to talk about it, but under normal circumstances, they'll review whatever is drafted and filed in writing, and then issue a decision to you. So following discovery, there are typically no motions for dismissal, unless there's something learned in the course of discovery, like that the MSPB doesn't have jurisdiction, or something of that nature. Very rarely is a motion to dismiss filed. So following discovery, you would have then another conference with the judge, and he would or she would issue a pre-hearing and hearing order. What this is it's depending on your issue, depending on the judge, they like specific things to be filed leading up to a hearing. That may be how many witnesses you're calling, who the witnesses are and why. It may be identifying their contact information so that the judge and the agency have it. It's also usually including the facts you intend to show. So if it's a removal, you intend to show that what the agency alleges, did not happen. This is what happened. There was no evidence provided. This is, the reality. Going through and citing the facts. Where in the record are you getting this information? If you're claiming X happened on this day, you write that as a fact, and then you just say, please see attachment 4 for what fact it is, what's showing that that's a true statement. There is also a possibility the judge will want you to summarize what you intend to prove at the hearing. What argument are you making? Was there discrimination? Was there retaliation? If the agency didn't meet their burden to show that this alleged action happened, or that they have the support for removing you, you're trying to include, this is what in reality happened. This is what the agency did not have, and you go through it. Basically, it's providing a roadmap for what may be discussed at the pre-hearing conference that a judge will order, as well as what the judge can expect for a hearing. So a pre-hearing conference will follow whatever deadline you have to submit pre-hearing submissions, the witness list, the list of facts, the documents. This pre-hearing conference usually is the judge deciding whether or not he's going to or she's going to allow certain witnesses, the order of witnesses, how many days the hearing is going to be scheduled for, more of like a housekeeping for a hearing. Following discussion of a witness, following discussions of housekeeping for what to expect at the hearing, the judge may also revisit settlement. He or she may ask you, do the parties want to talk about settlement? Are there any last minute exchanges? Do you need my help? They may turn it into a bit of a settlement conference. You're under no obligation to settle during these cases, but it can get costly at times, and sometimes the closer you get to a hearing, an agency is more willing to just resolve it, not go through it. Maybe you learn something in discovery that could change the tides, those types of things. So sometimes, this might be the last opportunity before a hearing for you to reach some sort of good compromising deal with the agency. So after this conference, the hearing will happen. Usually happens within 2 to 3 weeks, if not shorter, from whatever date you have the conference. The agency has certain types of burdens. You have certain types of burdens that you have to demonstrate in the course of the appeal. If you are talking about, misconduct, if it's a removal, a suspension, the agency has to prove their case by a preponderance of the evidence. Kind of to just summarize what that means, it's a more likely than not, a 51% or more chance that what they're alleging happened actually happened. You can refute this. You can, provide the evidence that you've collected, the statements, whatever you've seen from the agency. Your argument, your burden is to demonstrate that the agency doesn't have that level of proof, that they don't have enough to demonstrate that it's more likely than not. If you raise an affirmative defense like discrimination, retaliation, anything of that nature, you also have the burden of a preponderance of the evidence. You are trying to demonstrate that it's more likely than not that the agency official was motivated for discrimination, and trying to demonstrate for the judge the motivation, the connection between what the agency did, as well as their beliefs or previous statements or actions, or what they've done in terms of other employees. Do they treat someone of X race better than they treat of another? Now, during the hearing, you can expect, an introduction. The judge will provide to you their rules, what they expect, how they perform hearings. They will describe, if they have certain types of deadlines. If they do a hearing that's from 10 to 5, another judge might do 9 to 4. They'll describe all of that. They'll provide information. The judge will also provide to you any instructions or call-in conference information. The MSPB, like I mentioned, they've been doing virtual hearings for a very long time. So they will discuss or provide to you Zoom information, and all of that will be issued in official orders. These official orders will be sent to you via your email, whatever you use to register for that initial appeal way back when you first filed. So following that, following a hearing, you can expect an initial decision from the judge. It can happen, but it is rare that there is a bench decision, or after you go through your hearing, after the agency goes through their side of the case, sometimes a judge may issue a decision right then and there. It's oral. They will be on the record. There will be a court reporter taking all of this down. And they may say, you know, I find in favor of so-and-so, I find in favor of the agency. If they do that, they may or may not follow it up in a written decision, but typically nowadays they do. So if it's pretty rare that there is an oral decision, but it's not something that does not happen, and you should be aware of. Now, if you get an initial decision, it will be in writing. It will say that you have 35 days to appeal the decision. If you do not appeal within 35 days directly to circling back, if you don't file a petition for review to the board, the 3-panel board, within 35 days of that decision, your decision will become final. Then your only appeal right would be to file an appeal with the Federal Circuit Court of Appeals. So after that, you know, if it usually, right now, there is a 3-panel board. For a while, there was no 3-panel board. That was because the previous administration did not appoint or in the Congress did not affirm their appointment. So I believe it was just a short time ago that 2 more members were added to the 3-panel board, and they started reviewing cases that were on petition for review and pending. So there is a significant backlog. You can expect for petition for review, it usually can take between, at the moment, maybe more of a 2 to 3 years, if not a little bit longer, for you to get a decision. Once they catch up, it'll probably become much shorter of a wait. Just unfortunately, you're dealing with thousands of cases that were filed, and as people had still the right, and now the board, just three people are trying to work through quite a few caseloads. So just so you're aware of that as well, there will be a long wait for a decision on the board. Now, the benefits of having an attorney. You know, I know we went through quite a bit. I've been probably talking your ear off here for 45 minutes. It's a lot. This is a legal proceeding. It is something that is before a judge. More likely than not, you're going to have on the other side of the table an agency attorney assigned. There are a few agencies that do have more of a human resources specialist who's handling an appeal, but for most agencies, that's rare, and they're going to have an attorney. So sometimes, you know, there's going to be terminology, even though the judge is going to try to help to explain that to an individual who's representing themselves. Sometimes it can get confusing, and agencies probably wanting you to be confused. It's in their benefit to try to get this to drag out, to take this to a hearing. So in some instances, you know, during discovery, say, or making sure you meet your deadlines, or at the hearing itself, preparing, you know, a witness list, those types of things, it's extremely beneficial to have an attorney. It's not to say you cannot do it. It's just sometimes, you know, people find that it's difficult to keep track of that, or to remain objective in their case, or to find what types of legal requirements, you know, what is it that I'm missing? Is there some sort of standard that I can use? Is there a case that's similar to mine? All of those types of things could be provided by an attorney. Timeliness is probably one of the most important things when it comes to these types of appeals. If you miss a deadline, it's very hard to get it waived or excused. You can always ask for an extension of time before the deadline, but if you completely miss it, you did not see it, you're not aware of it, it's very hard to ask for forgiveness in these types of appeals. So just make sure that if you don't have an attorney, you're monitoring everything. You read those orders with a fine-tooth comb. But again, that is where an attorney can help you, because if one case has that deadline, all of them have that deadline, and we're calculating those already as it is. Another portion may be settlement negotiations. Sometimes having an attorney involved can remove you from having to even deal with the agency. And it's an argument that can be made about, whether or not the agency is actually, trying to pull one over on you, or understanding that they're talking to someone who went to law school as long as they did. Things of that nature. Sometimes there's more of a professional courtesy, or they're going to actually consider something. And then in the benefits of for you, you can have a conversation with your attorney about what maybe is what you should expect from your appeal. What's the most likely outcome? And then other types of things, if you're raising defenses, what you're requesting for in discovery, those types of things, that may be more beneficial to have the experience, or someone with experience, whether or not you're hiring an attorney to represent you in front of the MSPB, or you're just retaining an attorney to ask questions, feedback, advice when it's needed, just so that you can make sure that you are litigating your appeal to the best that you can. Because if you're challenging something from the agency, if you're challenging something from OPM, you're alleging discrimination under Ucera, you're dealing with something very serious. It's very serious to you. It's affecting your employment. If you're removed, it's costing you an income. If you're getting to that point, you're filing these types of things. It's definitely beneficial to have in some way someone making sure that you're keeping track. You're on the case. You're doing everything that you should be doing to win that appeal, because you get this one shot, this one appeal process. You can't refile it later on, or redo it. So things like that. It's definitely beneficial to bring someone on board with the legal experience. So with all of that said, there were some initial questions that were submitted about the process, and MSPB appeals in general. One individual did ask whether or not an individual has a choice between having their issue or their case managed before the EEOC or the MSPB. There were a lot of other questions about a mixed case complaint, or what happens if your case has, you're alleging discrimination, but you also have appeal rights to the MSPB. These cases are pretty complex, and I'm not going to lie that a lot of the times judges don't really know how to handle them, or EEO offices don't. You can file a complaint with the EEO office or the appeal to the MSPB. So going back to before, when I mentioned your choice of forum, you could only file in one or the other. This is where you would make that choice. If you are, for instance, you are appealing a removal, but you are alleging that your agency only is removing you because of your race. If you believe that there's discrimination, you can raise that in an MSPB appeal. What will end up happening is, at some point, the MSPB may reserve any decision on whether or not there's discrimination, and at the end of determining whether or not the agency just met its burden, do they have a good enough reason to remove you? After they issue that decision, they will kick it to the EEOC, the Equal Employment Opportunity Commission. A judge there will review your case to determine whether or not there's jurisdiction, or there's discrimination as well. So I know that's a little confusing, but what essentially to be aware of is, If you file it with the EEO first, it'll process through EEO, eventually get to a judge at the EEOC, and what the judge at the EEOC may do is kick it to an MSPB judge for a decision on what they have jurisdiction over, and then before it'll come back. If you go to the MSPB first, they'll go through it, reserve any decision about discrimination, kick it to the EEOC for a decision on that. So they're basically passing it off. The MSPB is not, under normal circumstances, going to make a decision about whether or not there's discrimination. EEOC is not going to necessarily say whether or not the agency did something, had preponderance of the evidence for their standard, in cases that you're appealing. It does, if you do, say, include in your EEO complaint that the agency proposed or did remove you from federal employment, at some point you're going to get, a notice of acceptance of your complaint for investigation. And instead of 180 days to investigate, the agency is only going to have 120 days. So it will lessen that by 2 months for the agency to investigate. But there's a lot more information about mixed case complaints that I'm pretty sure we could have a webinar just on that. So I'll leave it there, but you do have a choice, and it's going to be about how your case is processed and which issue is going to be reviewed first. Another question was whether or not, if the agency does not provide you appeal rights in its decision, is it a good reason to not file an appeal on time? In maybe some circumstances, but I would not, if you are getting anything that you remotely think could be appealed to the MSPB, I would file the appeal within 30 days of getting that. I would not, if you get a decision and then you think about it and it's, 2 months later to file the appeal, usually you have to give good cause, you have to explain. You can justify it by saying that the agency didn't give you appeal rights. They should. There, are certain requirements for them to put you on notice, provide information to go about filing an appeal. But the farther you get from an action being taken, the less likely good cause will be found. So just keep in mind, if it's even something remotely possible that you could appeal, file it. The worst that could happen is the judge comes back and says, well, I don't have jurisdiction over a 10-day suspension or something like that. How long do you have after an initial termination for an appeal? That, no matter what the action is, it's 30 days. So if you get a decision removing you from federal service on January 1st, you have 30 days to file the appeal with the MSPB. And then the last question was about crafting discovery requests. In general, you're going to be wanting anything that could be relevant to your case. If you're alleging discrimination, did the agency officials involved talk about you? Did they send emails, instant messaging? Did they consult with HR before they issued the decision? Things of that nature you may want to have. If the agency didn't really give a lot of information about why they're taking the action they are, you're going to want that type of information. The general rule of thumb is that, you get 30 requests for information, 30 requests for documents, and then you can even ask for 30 admissions. You can make a statement and ask the agency to admit or deny if it's true. What to do is an example of a document request would be, requesting your entire permanent personnel file, or emails between so-and-so, from 2020 to present, discussing the appellant, or discussing my performance, those types of things. If you're asking for facts, describe in detail why the agency believes I did this, or describe in detail why the agency thinks that it's supported by the evidence that I did conduct unbecoming. Things like that you're going to be asking, and each question is one request. So with all of that said, are there any other questions? Let me see here. I do have some. If you file an EEO complaint after you file an MSPB, EEO is going to dismiss it. The MSPB is going to be the one where you've chosen to litigate your case through. So eventually it may get before an EEOC judge, like I mentioned, but if you choose the MSPB first, then EEO is going to ask you a question about that, and it's going to be grounds for dismissing your complaint, and the agency doesn't have to investigate it. Are there due process rights during a probationary period for termination? It depends on exactly what they're raising. If it's about suitability, if they learn that before you are appointed, that you didn't provide accurate information, if you did not complete, if there's a security clearance that verges into another area of law and an appeals process. It depends. If it's about suitability, if it's about incorrect information, you should have an ability to respond to that first. But it may be that they could remove you. As far as due process, your ability to respond, that's going to be just as limited because of your probationary period status. Let me go up through here. Couple other questions that I believe we still have a couple minutes here. Give up. What legal actions does an appellant give up by filing an MSPB appeal, filing in circuit court? So if you are there is only certain types of appeals that can be filed with the MSPB. So if you are filing an MSPB appeal, then you are giving up more than likely a potential for a union grievance. You are waiving the EEO complaint in regards to that claim. So that again gets into that mixed case. Filing in circuit court, it depends on why you would be doing so. For federal employees, you're limited in what kinds of actions you can file directly in federal court. And that's probably a whole nother webinar on that. But as far as legal rights, it's more often it's the other types of administrative processes you have in challenging a suspension, a removal, a realignment, a reassignment, reduction in force, those types of things. See if there's anything else. Security clearances is a different area. You typically are not appealing a security clearance decision, whether that's it's being revoked, it is being denied. You're getting a proposed, I believe it's a request for a statement of reasons. Those types of things are actually a completely separate process from the MSPB. They're not going to want to touch it. They do have their own appeal. You have your own response requirements and deadlines for that. So that anything with your security clearance is going to be something different. Let me see. If how long does OPM have to respond to a timely filed request for reconsideration? I believe OPM has well, no specific deadline. OPM can unfortunately take as long as they want. You would still, regardless if it's 6 months, 2 months, a year that OPM gets back to you, you would have essentially 30 days from whenever they give you that final decision to appeal to the MSPB. So there is some case law in support of if OPM has not responded to you within 18 months, that you could file an appeal with the MSPB saying that they constructively denied you something. There's some support for that. However, it depends on the judge, what the issue is, things of that nature. But generally speaking, until you get a decision, you have 30 days when you get that decision. What happens if your discovery questions are not answered even after a motion to compel? If if there's still no discovery response from the agency, and you filed a motion to compel, the agency's responded, you're just putting it into the hands of the judge. At some point, the judge is going to have to issue a decision, and if the judge could order that the agency produce certain responses, all the responses, it would depend on what was being raised in the original motion. But the judge should eventually issue a decision, and it should be in some form of either granting and compelling the agency to produce, or saying, no, I think the agency's right, and refusing to respond. The judge will give them a deadline. It may be, you know, by May 31st, the agency has to provide all information that's being requested and ordered here. And then the appellant has X amount of days to let me know if there's issues, those types of things. I think we have a couple more. Let me just read through them here. So there is a question about someone who had an oral reply in regards to a proposed action, and they are now waiting for the agency to respond or to provide a final decision. It depends on how long. The question is about how long is the wait for the agency to actually respond to it. It depends on the type of action. It depends on what authority they are making the proposed action under. You know, the VA, if it's, you know, misconduct performance, they tend to issue a decision pretty fast. It's usually within a certain type of regulatory deadline. I have also seen it where if there's no regulatory deadline, an agency come back in 10 months with a decision on a suspension. It's just, you don't have to serve the suspension until the decision comes back. If the decision comes back, it could be a reduction of what was proposed in the first place. But you should know and you should receive a written final decision. And until you receive that written final decision, you're not able to appeal to the MSPB in those instances. So the day you get something, that's the day the clock starts running as far as going forward with an MSPB appeal. So we just have a couple other questions. Let me just make sure if there's anything that I can address here. I believe that would be everything that I can see then. So I think those are all the questions.
Great. Thank you, Amanda. If you do have any additional questions regarding the topics covered today, we've provided some contact information on screen. Please feel free to reach out and we'd be happy to connect you with Amanda or another attorney from our Federal Employment Law Group. Just as a reminder, or if you joined late, today's presentation was recorded and we will be circulating a video link and a copy of the slides as well. That'll be tomorrow via email. And today's webinar was part of our ongoing monthly federal employment webinar series. We'll be announcing our October webinar topic in the next few weeks, and we look forward to seeing you there. Thank you, everyone, for joining us today, and thank you, Amanda, for taking the time to present. That'll be all, and thank you, everyone. Have a great day.